So once again, we welcome everyone to our the Rural FASD monthly speaker series. We are absolutely thrilled to be joined by Shelley Toland, who is the coordinator for the Capacity Assessment Office. And if I can get it correct, I believe it's the Capacity Assessment Office is also part of the Office of the Public Guardian and Trusteeship under the Ministry of the Attorney General of Ontario. Do I have that right, Shelley?
Well, I'm going to tweak that just a little bit in my first slide. So,
okay, perfect. So we are part of why we're so thrilled to have Shelley here is we know from a caregiver standpoint, a lot of our children with FASD that we're currently the primary caregivers for, as well as our adults, money management and finances is always our options and how to best work in those situations. And so Shelley is going to be sharing with us one of those options that can certainly be explored. I can tell you from my own personal standpoint that it is an option that we have certainly tapped into at this point. And so thank you very much, Shelley, for joining us. And absolutely. Before we begin, I just want to acknowledge that we are on the traditional and unceded territories of the Anishinaabe people, where we currently work, play, and pray. And with that, Shelley, I turn it over to you.
All right. Thank you so much, Rob. Good morning, everybody. Thank you for having me. Can everybody hear me okay? Okay, so I know it's a little choppy on this end, but if I have to ask you to re-ask your questions, that's no problem. So thank you again for having me. And so just to tweak what Rob said just a little bit, okay, the Capacity Assessment Office is actually a standalone office and is not technically a part of the Public Guardian and Trustees Office. Although I do share resources with them and I work out of their office, we are technically standalone. And if you understand the role of a capacity assessor and the fact that most of the assessments that they do are what we call Section 16 capacity assessments. And if the person is found incapable, then that person becomes a client of the Public Guardian and Trustees Office. So it's a bit of a conflict of interest there. So we technically are a standalone office, but we do work under their umbrella through the Ministry of the Attorney General's office. Okay. So the Capacity Assessment Office is responsible for recruiting and training capacity assessors. I maintain a list of those qualified assessors that are currently on the roster. I provide consultation services and continuing education to those assessors. And I administer a financial assistance program that is available to low-income individuals who may not have the funds available to pay for a capacity assessment. I also respond to public inquiries about capacity assessments. And as I'm doing today, I do public outreach and education about capacity assessments. So the legislation that the Capacity Assessment Office falls under is what we call the Substitute Decision Act. So the Substitute Decision Act is what guides our assessments and our legislation. So the first thing I wanted to show here was the biggest thing about doing any capacity assessment from the standpoint of our assessors is presumption of capacity. A capacity assessor must go into every capacity assessment, presuming that person is capable, and then they must find the evidence to prove otherwise based on the definition, which is below. So for property, person is incapable of managing property if the person is not able to understand information that is relevant to making a decision in the management of his or her property, or is not able to appreciate the reasonable foreseeable consequences of a decision or lack of decision. Now, just to point out one small thing here, the legislation is based on 1992 language. So his and her, the government has changed to a gender neutral policy. So hopefully at some point in the future, legislation will catch up with the gender neutral policy, but that's why his and hers is still in there and not their property. Okay. So I'd like to point out the not able to in red, because this is not a matter of the person just doesn't want to do it. It's whether or not the person has the capability, the cognitive ability to actually have the function to manage their finances. Okay. So for the, oh, did I go? Oh, and the age for the property assessments, the person must be age 18. Okay. Anything younger than that, an assessment cannot be done until they turn 18. Whereas the personal care side of things, the personal care assessments follow the Healthcare Consent Act age, which is 16. So a personal care assessment can be done at the age of 16. But again, there has to be a reason for that assessment, and I'll get into it just a little bit in the next slide. But again, it's about the ability to are surrounding the domains that are noted in the legislation, which is healthcare, nutrition, shelter, clothing, hygiene, and safety specifically, okay? So a capacity assessment is done under the Substitute Decision Act, is a legal assessment. It's not medical, it's not clinical, it's a legal assessment. And it's to determine if the individual has the ability to understand or the ability to appreciate their decision or lack of decision. Okay, a designated capacity assessor at the request of an individual will try to determine whether a person's understanding of the issues is factually correct and or will assess the person's level of mental functioning and their ability to reason and process that information. That is the general scope of how they proceed when they do assessments. When is a capacity assessment required? So the biggest one is when there is now some need for somebody to step in and manage that person's finances because there are concerns about cognitive ability and them not being able to manage, and there is no existing continuing power of attorney. Okay, so if there is no continuing power of attorney and the person does not have the capacity to grant a power of attorney, the only way somebody else can manage their finances is through a capacity assessment, or you can go to court and ask the court to grant guardianship. But the most common way is to get a capacity assessment done. The other reason a capacity assessment is required is when a power of attorney has a specific clause that states the person's mental capacity must be proven under the Substitute Decision Act before the continuing power of attorney comes into effect. If the continuing power of attorney does not stipulate how their mental incapacity should be proven, a capacity assessor's opinion may be sufficient, or what we call a letter of opinion. So what is a continuing power of attorney? So a continuing power of attorney is a legal document that gives someone else the right to make decisions on that person's behalf. You can't ask or get a power of attorney. It has to be given to you by an individual. Who is allowed to make a power of attorney? Anybody age 18 and over who has the mental capacity. Okay, and there is a definition in the Substitute Decision Act under Section 8 for property of what the criteria is to determine somebody's capacity to grant or revoke a power of attorney. If somebody has the capacity to grant a power of attorney, they have the capacity to revoke a power of attorney. It's the same criteria. Okay. Personal care assessments, and this is one of those questions that I get a lot from social workers, hospitals, long-term care facilities. Personal care assessments are only done under the SDA, the Substitute Decision Act, when somebody is going to court to obtain personal care guardianship. Personal care assessments are not to be used by a third-party service provider to decide about the person's capacity to make healthcare decisions. That's where the Healthcare Consent Act comes into play. Okay. You're okay, Rob? Every good? You're hearing me okay?
We're just, our internet connection's a little bit unstable on this end, but
yeah,
perfectly good.
Yeah, so just like high five me, do something if you want me to slow down or if you want me to repeat something, okay?
Sounds good.
All right, so I mentioned earlier that I'm responsible for maintaining the capacity assessor roster. So assessor rosters include the assessor's geographic location, the languages they speak other than English, their professional qualifications, and their area of expertise. The link is in this slide presentation, but that is the website you can go to for the capacity assessor roster. I do have a PDF version available if you ever need it. And to be quite honest, it is a lot more user-friendly than the online list. We are working on that with our digital services, but it is not the greatest at this moment. So when choosing a capacity assessor, the things that you should consider are the proximity of the assessor to the client, because you will have to pay travel fees to the assessor, the assessor's availability, matching the client's needs, preferences, and professional expertise to the assessor. So if an assessor is not comfortable dealing with somebody who has dementia, or not comfortable and don't have the experience dealing with people with intellectual disabilities, if they don't have that noted on the roster that those are populations they're comfortable with, you should move on to somebody else, okay? And I do always recommend that you obtain estimates from the assessors, because they do charge varying rates, and some charge hourly, some charge flat. So I do always recommend getting a couple of estimates, okay? So having said that, and this is the biggest bone of contentions usually about assessments, is the cost. So fees are determined by the assessor and the regulatory college based on their guidelines. I do not have any say in the cost of an assessment. That is solely based on through the college and their fee guidelines. Usually, on average, I'm hearing from the assessors and the public, the cost of it can range from $800 to $1,000 plus, or as I mentioned previously, some do charge a flat rate. It does depend on the complexity of the assessment, how much they're likely going to charge. The requester usually pays for the assessment. The requester may be able to recover the cost of the assessment from the incapable person's estate. And one of those ways of doing that is if the person does become incapable under Section 16 and the public guardian and trustee's office becomes their guardian and is going to remain their guardian, you can submit the paid invoice to the public guardian's office and ask to be reimbursed from the client's funds. The public guardian's office will not reimburse you. It's not government funds that will be reimbursed to you. It is actually coming out of the client's funds, okay? And it's up to the public guardian and trustee's office if and when that gets done, because their priority is basic needs and shelter as opposed to paying debts or liabilities. They do have to note on the file that it has been requested to be reimbursed, but again, it will be up to them to decide when that gets paid, or if, okay? So the assessment steps. So if nobody is coming to the capacity assessment office for funding, it's very straightforward. The capacity assessment office has a financial assistance program available, which we'll talk about in a second. So contact a capacity assessor, set up a date and time for the assessment. If that person is found incapable under Section 16, then the assessor is required by law to submit the report to the public guardian and trustee's office. I usually tell the public to ask the capacity assessor when they think the report will be submitted to the public guardian's office. Give the public guardian's office at least 72 hours to be able to open that file and assign it to a client representative. Okay, and the 1-800 number is noted here, where you can call after the 72 hours and ask to speak to the client representative who's been assigned the file. Okay, if you are planning to replace the public guardian and trustee's office as guardian, then that is the time to speak to the client representative about your decision to replace them. Okay. So here's my contact information. The 1-800 number is actually our PGT contact center. So if you have a general question, you're supposed to go through the PGT contact center first. And if they can answer your questions, they will do so. If not, they will send me an email and ask me to get in touch with you. Or if you want to just email me directly at cao@ontario.ca and ask me to call you or ask me a question and I'll get in touch with you, by all means, please feel free to do so. Okay, so that's it. That's the end of my presentation. So I'm going to stop sharing here. And now we can just open it up to the floor for questions. comments, concerns, what's going on? Why did you lovely folks want to chat with me today?
So first of all, thank you so much, Shelley. We, like I said, we've definitely, this is new territory for all of us and a subject of a lot of conversations around even capacity.
Oh, you froze on me. Oh, sorry, you're freezing on me, Rob.
Found the way you're communicating right now in terms of how easy it is to get a hold of you, how easy it is to be able to work with our capacity assessor, that entire process. We're not used to things going easily and smoothly, particularly when we're working with folks from the government. So however, I can absolutely say in your particular case, it very much was very smooth and easy to do. So
glad to hear that.
Thank you so much for that. With that, we do want to let our studio audience know that we will be taking once again our December break because we have our special guest from the North Pole who always joins us for our December meeting, but we will be back in January with our next presentation following that. So with that, we will see you in the future.
Now, this question.